Hi, it's Ro again. We are nearing the end of our journey through criminal trial procedure. Just as there is a lot that goes on ahead of a criminal trial, a lot can go on between the verdict and the sentencing. In many cases, there is a pre-sentence investigation done by the Department of Corrections to gather information on the legal and personal history of the person who has been convicted. The goal is to provide information to the judge to help determine appropriate consequences. Someone with a previous criminal history is likely to get a harsher sentence than someone for whom this is a first offense. The pre-sentence investigation report often includes information about issues and needs that should be addressed if the person is going to have the best chance at rehabilitation. Things like substance abuse or health issues, educational or financial barriers. As part of preparing the report, a probation officer interviews the defendant and may talk with other people involved in the case as well. The victim has an opportunity to prepare a victim impact statement if they wish, that will be included as part of the pre-sentence investigation. The victim impact statement is just that, a written description in their own words of how the crime has affected their lives. This is often the first and only part of a criminal trial in which the victim gets to say what they want to in their own way, without being limited to what questions they are asked or what they are allowed to talk about. Once all the information has been gathered, the probation officer often includes a recommendation to the judge on what the sentence should be. This report is given to the judge, the prosecution, the defendant, and the defendant's attorney before the sentence hearing. At the hearing, the judge has a number of factors to consider in imposing a sentence. There are sentencing guidelines set by the state legislature, laying out what would generally be appropriate for the severity of a crime. There are mandatory minimums for some crimes, including domestic violence. These laws limit some of the judge's choices. There are other issues of community safety, resources available for treatment, jail overcrowding, previous plea negotiations, community standards, personal beliefs about law and order and rehabilitation that influence the judge's decision about the sentence. The defendant wants to present any extenuating circumstances about the case or their situation that will influence the judge to be more lenient. They may describe what they've learned so far and express how sorry they are. They may have already begun counseling, treatment, or other intervention programs to show they are ready and willing to change their behavior. Sentencing hearings are usually short. The judge will ask the defendant if they have had a chance to review the pre-sentence report and go over it with their attorney. The defendant will have a chance to make a statement if they choose. The prosecution can make a formal request or recommendation for sentencing. The judge may also give the victim a chance to address the defendant from the witness stand or read their victim impact statement out loud. With that, the judge pronounces the sentence, which is some combination of probation, jail time, fines, victim restitution, requirements for assessment, or other actions. The defendant is also assigned court costs. The judge may continue a previous no-contact order, ordering the defendant to stay away from the victim, or enter a new one. Different kinds of sentences and how much jail or prison time someone actually serves is a whole topic itself, so I'll end this series of videos on the trial procedure here. I hope they've been helpful, giving you an idea of what to expect, and separated reality from the fiction we see so often in the media.